We are back on the record for the conclusion of the termination trial review hearing and permanency planning hearing for the third day. Thank you everyone for coming again, and let's do appearances and get started.
Lee Heiss, lawyer, guardian ad litem.
Stephanie Hamlin, department.
Ms. Sasha Thomas, counsel for the department. Ms. Hamlin.
Department of Health and Human Services, foster care.
Good morning, Ariel Berger here on behalf of the mother, Caitlin Estes.
Caitlin Estes, mother.
Thank you. All right, all that remains to accomplish, as I understand it, is the closing arguments. So, Ms. Thomas, whenever you're ready.
Thank you, Your Honor. I know that this case has a lot of information in the record. To the best of my ability, I will keep this short. And first, I want to say that the department, and I think everyone recognizes the progress that Ms. Estes has made in the last few months. And that cannot be denied. And we're hopeful that she can maintain that consistency in her life and stability in her life for herself moving forward. But at this point in time, these children have been in care for 2 years, and she has had 2 years to work through, essentially, or a year and a half to work through a case service plan to demonstrate her ability to achieve stability and some of these baseline needs that the children have, such as housing, employment, stabilizing her mental health, completing and benefiting from parent education services. We had one little one who had broken legs or broken bone that was found to be non-accidental. We never knew how that happened. And it's the same little one who was appropriate during parenting time recently, or during the spring. And that's after services for parenting were provided for a significant amount of time. We were never able to transition to unsupervised parenting time because of the lack of progress, because of the concerns, the safety concerns for the children. Now we're being asked to maybe give her 6 to 9 months so she can demonstrate this stability, so she can demonstrate what she's learning in classes. But some of these children have been in care their entire life, and all of them have been in care for a majority of their entire life. It's not reasonable to expect that there would be a change within a reasonable amount of time for their ages. Additionally, Ms. Estes has had employment throughout the case, albeit inconsistent, but she has the ability to work and provide financially for the children, which was and has been limited in what she has provided for them financially and materialistically. And again, it's the timeliness of this whole case that really emphasizes how much effort was put forth by the department and by the agencies to get referrals and to put services in the home that met these children's needs, that met the mother's needs. And there was always there hasn't been a demonstrated benefit from it. And maybe there's an argument that because she hasn't had parenting time, she can't demonstrate that benefit. But the reason she doesn't have parenting time is not because anything the department did. It's not anything the children did. It's because of her inability to parent safely for these children during supervised parenting time. The reasons that this case opened were substance abuse, homelessness, domestic violence, with both parents being perpetrators and victims of the same. And that has still been ongoing, even until very recently. And there's no demonstration that that would be resolved either. And most significantly is the parenting ability. And moving forward, the children, because of that inability to achieve those goals and to rectify the conditions that cause the children to come into care, there is a strained bond between the children and Ms. Estes entirely. One thing that stood out from Ms. Estes' testimony yesterday was how she referred to Brooklyn as her best friend. She was the one she turned to, spent the most time with, and that's a really inappropriate way to describe a relationship with your child. Children are not friends, they're your children. And the fact that there's limited bond still with Abby, and a couple of review hearing ago, she testified that she was tricked into having parenting time with Abby, so she didn't do it, rather than accepting the parenting time with Abby and moving forward with it. She had an opportunity to secure a bond with her children, especially Gideon, when, as Miss I'm going to butcher her name, Grandma, provided the very liberal parenting time at her home when Gideon was first born. All of those were opportunities to establish a bond and to move forward with that, and she failed to take advantage of that and to do it. These children are very young. They are thriving in an environment that provides them with routine, stability, and they are in need of finality. At this time, their behaviors, especially for Brooklyn, have been reduced, the aggression that she was experiencing, and it seems that they have become more developmentally appropriate at this time. In the Miss S's parenting ability throughout the case, she has not been able to demonstrate the ability to manage 4 children on her own. The ambivalence about her parenting, and all of this is in our petition, which we rely on for closing as well. And although the children are in a relative placement, and that typically weighs against termination, the relative placement did not benefit Miss Estes the way that we would hope it would. She was provided extra time. She was provided an additional support with that liberal availability to her children to be in the same home as them, to celebrate holidays and birthdays and all of those things, and to have that close contact. And it did not benefit their relationship or this case in the way that we had hoped, but it did buy her a significant amount of time. And changing a caseworker 15 months into the case also bought her a significant amount of time. These children also have a lot of medical needs, a lot of appointments that need to be attended to. And the foster family, the grandparents are with the support of extended family members, continue to get them where they need to be. The early on assessment that we got in our court report this time also indicated it gave us a picture of the attachment that Gideon has with his aunt and cousin, adult figures, caregivers who take him to appointments, and he can demonstrate that he has that attachment with them. We don't have that here with Miss Estes. It does not exist at this point in time. Even if this court were not to terminate her parental rights and to allow her to have more time, we would then need to have a period of reintroduction. And what would that look like for children who have had this inconsistent back and forth with her? In addition, then what if she doesn't maintain the stability and maintain the supports that she has in place? And we have to take those children away from their mom again, or their mom goes away again. I think that is a lot of back and forth, and that really disrupts their stability and the finality that they deserve and need at this time. I think a lot will be made about the fact that Miss Estes has significant support right now. And I think Miss Heiss pointed it out yesterday. Where were these people for the last 2 years? And what happens if there's another falling out? What happens if maternal grandmother doesn't like something that Miss Estes does? Does she stop providing care? Does she stop helping with transportation? If she's in a relationship with someone that her father does not like, does he kick her out? Does she have an ability to maintain her own independent housing? And those are realistic questions that we have to ask, given the history of this case, the back and forth between her and Mr. Hamlin. And I would ask the court to consider all of those things in making its decision today. But for those reasons, we do believe that there's clear and convincing evidence that at least one of the statutory grounds pled in our petition have been proven, and that it is in the children's best interest to terminate Miss Estes' parental rights so that they can be adopted and provided permanency. Thank you. We can't hear you. Ariel, can you hear me?
Yeah.
Okay.